Good evening. Happy Wednesday? Something like that. I was wrong. I was wrong in my analysis of the ADA as it applies to quarantine. And if I was human rather than an attorney, I would be embarrassed by how wrong I got it and by how I got led astray. I was talking about quarantines, and I allowed someone to reframe the issue as you need more than probable cause to quarantine someone. That's why schools can't exclude children who are HIV positive. And, there's a lot wrong with that particular sentence, equating quarantine with exclusion from schools. I mean, there's a lot wrong with it. But the one thing that was wrong with it that I didn't catch, that I allowed to change my mindset, was that we stopped talking about the quarantine in Henry Martin, where the state didn't know whether or not these ladies were infected, and we started talking about kids who were HIV positive. We stopped talking about people who may or may not have a disability, and the point of the quarantine is to determine whether they do, and we started talking about kids with disabilities. Now, I was wrong because of that, I stopped looking at the qualified individual with the disability, reason of such disability. I started looking at services, programs, or activities, and you've really got to torture the definition of quarantine to be a service, program, or activity, and you have to torture it further to have it, someone have to meet the essential eligibility requirements for the receipt of quarantine, with or without reasonable modifications to rules, policies, or practice in order to be quarantined. It didn't fit. It doesn't work. I don't like it. But you know what? Lawyers have tortured definitions far worse than that. So it's possible. I wasn't very happy with the analysis of it. I felt like, in a worst case scenario, I certainly would throw the ADA out against, if I was getting paid to represent someone in a quarantine, I would throw the ADA at whatever entity was conducting the quarantine. And I would do that because, you throw the kitchen sink, you throw all of the spaghetti at the wall, hoping that some of it sticks, because all the spaghetti that you don't throw will never stick to the wall. And you want as many opportunities as you can get for that judge to rule in your favor. And so I was very unsatisfied with it because I knew that there wasn't any litigation on these quarantines. And yet the explanation didn't really work for me. So now in that context, now that hopefully, you've been paying attention, that the ladies in Henry Martin didn't have a disability, or the state didn't know they had a disability. If the state was acting without addressing whether or not they had a disability, the point of the state's action was to determine whether or not they had a disability. Because I will admit that having an infectious disease is probably a disability. I don't see why it wouldn't be. So, with that said, these gals weren't being treated, they weren't being discriminated against on the basis of a disability. They were being quarantined to determine whether or not they had it. Now, another thing is that I was criticized for suggesting that all that it takes is the equivalent of probable cause. And that's down in here in Henry Martin. And it doesn't say probable cause, it actually says reasonable cause. And it calls it the equivalent, the civil equivalent of the level of proof required on a preliminary examination before a magistrate prior to commitment on a criminal charge. And I was told that I was wrong about that. Well, This is a 2016 case, so if you're worried about the year of it, this is a much newer case. In this case, Hickox was a nurse. She went to Africa during an Ebola outbreak, and she went there to help out. She was a nurse, and she went there to treat these Ebola patients, and she took all the required precautions that she needed to do so safely. Well, anyway, she came back to the United States after having treated these people in Africa, and she ran face first into New Jersey's blanket quarantine on people returning from Africa from Ebola outbreak spots, zones, who were medical professionals, people who worked in the medical field, doctors, nurses, probably nursing assistants as well. She ran into a quarantine, and she didn't like it. They held her for 80 days. They held her for a few days, like 2 days, I think, and they got back the Ebola test, and she had tested negative. But then, since she was running a fever, they held her a little longer. So they ended up holding her for 80 hours, which is a little over 3 days for those of you who are doing the math. And she didn't end up having Ebola. So she decided to sue. And this is just a district court case, but this case is I think relevant for a very specific reason. The reason it is relevant is because there is not a lot of quarantine case law. The judge looked for it. I'm sure the attorneys looked for it on either side, and the judge couldn't find it. And so it's a very small quarantine case law. And then he switches over, because it's a 1983 lawsuit and because he could just switch over to civil commitment case law, which is different than quarantine. But it's similar. But he switched over to it. And I think he did that because the attorney for the plaintiff argued that he should use civil commitment case law. And he looked at all of it, and he said, even if we did apply the types of analysis in civil commitment case law, this would still be valid. It would still be a valid exercise of state power. But one fun thing is that they looked at the Fourth Amendment. Now, when In re Martin was decided, Mapp v. Ohio, which is the case where the Fourth Amendment was incorporated into the 14th Amendment, In re Martin was decided before Mapp v. Ohio. But In re Martin came to the same position as these subsequent cases did in civil commitment. And they came to the same decision. The judge actually says up here in the quarantine section, this is the quarantine section somewhere in here. There we go, quarantine case law. He says up in here that the Fourth Amendment does apply, he believes, but he's going to he will do a Fourth Amendment analysis in the following section because, again, there's just more case law on it for civil commitment. So he does apply the Fourth Amendment analysis, and he says that the standard of, or the burden of proof is probable cause. The standard is probable cause. So it is just like In re Martin, and it is a 2016 case. One other thing to note about it is the attorney for the plaintiff throws everything out there. There's my substantive due process. He throws out the procedural due process somewhere in here, both of which I think are going to be determinative in a lawsuit over the stay-at-home orders, I think. But I'm just a first-year family law attorney who screwed up the ADA analysis, so what do I know? He also throws in state law claims. I mean, this guy, invasion of privacy, false light, false imprisonment. I mean, he threw all the spaghetti at the wall, but the one thing he didn't throw at the wall was the ADA. And I mean, you might want to say that he was a bad attorney, but you got to remember that it was Edward Barocas, Janine Lociero of the American Civil Liberties Union. The American Civil Liberties Union has been fighting quarantines and segregation and things like that for a long time. The American Civil Liberties Union is very familiar with the ADA. If the ADA applied, it would have been in here. If there was a remote possibility the ADA would apply, it would have been in here. It's not in here. Now, I've been accused of stigmatizing these two gals in Henry Martin, and I don't think I have. I have recounted the facts, but there are some specific things that I'm being accused of stigmatizing them about. Number one, they were kept in jail. Now, I don't know why I am responsible for that, but there is a reason why they were in jail. They were arrested for vagrancy, and they were given a bail. They were given bail, $500 each for bail. But because the county health officer had determined that there was probable cause, or the equivalent of probable cause, that these gals had syphilis, they were kept in quarantine at the jail. They weren't thrown in jail because it was 1948. They were thrown in jail because that's where they were, and it worked. They had been charged with vagrancy. Now, they've been charged with vagrancy because there was a disturbance at a local hotel that in the past had problems with prostitution. Now, that isn't enough in itself to try to say that these gals were prostitutes, or that they were more likely or less likely, or that there's probable cause that they had syphilis. But they failed to follow one simple rule. They talked to the police. Never talk to the police. Kitty Andrews admitted to having worked as a prostitute during the last 2 years. And Dorothy Martin, the Martin of Henry Martin, admitted trying to run a house of prostitution. They talked to the police. They gave the police the probable cause. Now, today, venereal diseases are different. Well, maybe they are, or maybe they aren't. But the way we test for venereal diseases is different. The treatments that we have for venereal diseases are different. I'm not entirely sure. I think that even AIDS tests are fair, or HIV tests are a fairly quick process. You get the results back in a fairly rapid manner. I'm pretty sure that you can get results back on other venereal diseases in a fairly rapid manner. So it might not make sense as a policy in today's day and age to try to quarantine people for 10 minutes. It might not even make sense with advances in medicine to really spend as much time and effort as they were in trying to corral these cases of syphilis, because back in the 40s, it was different. Medical science was different. But I just want to say that I'm not trying to judge these people. And I initially brought up Henry Martin because I was not happy with the fairly low level of proof. I don't like the idea that someone can be quarantined based on probable cause. That is such a low standard. I don't like that. I don't like civil commitments, which the first 72 hours is also a probable cause standards. It is a terribly low burden of proof. Now, at least with civil commitments, and I would assume with quarantines, that with civil commitments after that 72 hours, if the state wants to continue it, then they have to meet a clear and convincing. That first 72 hours it basically gives the state time to do the investigation. It maintains the status quo while the state does the investigation. And they could only do it if you're a danger to yourself or to others. So, I mean, there are some protections in there, but it's just a little sketchy to me that state can do this kind of stuff to you, put you in jail when you haven't committed a crime, put you in an institution when you haven't committed a crime on probable cause that you're infected. I mean, I don't like it. So don't take me reading the law to you and giving you my interpretation of what the law is as me endorsing a law. That's not what I'm here to do. My political beliefs are different than a lot of the cases that I read. I am just telling you what my best interpretation of the law is. If you get emotionally invested in it, if you can't handle that, that's your problem, not mine. Thanks for watching. Have a great day.